Good morning, and welcome to Frenemies, the series which helps marketers and legal departments understand each other, work together, issue spot, and maybe go from being frenemies to friends. If you had a chance to watch Frenemies Season 3, Episode 1, Parts A, B, C, D, E, etc., you might recognize me as Justin Yetter. That is, if you can see me. I'm broadcasting today in the dark in order to shed a little bit of light on California's Shine the Light law, and I'll also do a bit of comparison between Shine the Light and CCPA. If you want to learn more about CCPA, I'd encourage you to watch the earlier episodes in this season, as they provide a broad overview of that statute. In the beginning, there was darkness. Then, in 2005, came Shine the Light. But seriously, 2005 was a really long time ago. And now with CCPA, we have a broadly applicable data privacy law. So why are we even talking about Shine the Light? Well, Shine the Light is still on the books, and it includes some specific requirements that are different from those of CCPA. Now you ask, why wasn't all of this just incorporated into CCPA? Unclear. But let's focus on what we do know, what Shine the Light is and what it is not. Shine the Light is a 2005 California law providing information rights and an opt-in, opt-out right when a business discloses personal information for a third party's direct marketing purposes. Shine the Light is also still in effect after CCPA. What it is not, it's not a comprehensive data protection law. It's not a general opt-out for use of personal information. There's no right to deletion of personal information. It's not applicable to any use of personal information other than when used by third parties for their direct marketing. It is not a limitation on a business's ability to use personal information for its own marketing purposes, nor is it a prohibition on joint marketing as long as certain requirements are met. The most important takeaway here is that Shine the Light is very narrow. It only applies where the personal information is used or where a party reasonably should know it's going to be used for third-party direct marketing. When does Shine the Light apply? There are multiple requirements. First, there must be an established business relationship between the business and a California consumer. And an established business relationship essentially means either that there is an ongoing relationship, or if the relationship is not ongoing, that there have been less than 18 months since the time of purchase of the product or service from the company. Note that if the relationship is ongoing, a purchase need not have been completed in order for Shine the Light to apply. Second, disclosure of personal information to a third party in the preceding calendar year. This covers virtually any type of disclosure. And third, the business must know or have reason to know that the third party used the personal information for the third party's direct marketing purposes. Now, how would a company have reason to know that a third party is using personal information for its direct marketing? This is typically going to be a matter of reviewing the relevant contracts to see if marketing is either stated as a reason for transferring the information to the third party, or if the contract does not prohibit the third party from using the information for its own marketing purposes. So 3 requirements in order for Shine the Light to apply, and all 3 must be met. If any of these are not met, the law does not apply. How does a business comply with Shine the Light? There are 4 basic ways. First, the business can publish a privacy policy providing for an opt-in consent before sharing personal information for third parties' direct marketing. Or the business could use an opt-out method in which it tells customers how they can opt out of the sharing of personal information. Third, the business could approve a method for customers to request an accounting of personal information. And this accounting has some pretty specific rules under Shine the Light, and it only applies to information within the preceding calendar year. And then last, the business could comply with the Gramm-Leach-Bliley Act's disclosure requirements, supposing those apply. And then last, as I mentioned, there are some detailed rules for accountings. However, the accounting under Shine the Light can be standardized. It's not like the CCPA right to know where it has to be specific to an individual customer. Instead, similar to GLBA, there can be a sort of more form type disclosure that can satisfy the accounting requirement. So it probably sounds like Shine the Light is on a collision course with the CCPA. Let's look at some of the details, and we can see how the two statutes compare to one another. Overall, CCPA is far broader than Shine the Light, but Shine the Light has some features that don't completely overlap with CCPA. So looking at a few of these, the definition of personal information is different in Shine the Light than in CCPA. They have a lot of overlap, but CCPA is broader. Unlike CCPA, Shine the Light requires an established business relationship. In other words, Shine the Light applies to customers, whereas CCPA applies to any California consumer. Both apply to sales of personal information for third parties' direct marketing purposes. However, Shine the Light is not applicable to any other uses or disclosures of personal information. Both provide a right to opt out, and both include a right to opt in. However, for CCPA, that right to opt in is really only used for minors. Shine the Light does not include any right to deletion of information, unlike CCPA. And the right to know, that is in truth a CCPA right, but the accounting under Shine the Light is pretty similar. And so I think it's fair to say both include a right to know. It's just that Shine the Lights is more limited. The other difference is that there are different response times for providing the Shine the Light information versus responding to requests under CCPA. For Shine the Light, you only have 30 days, whereas in CCPA, you have 45. That's really important to keep in mind because you need to make sure you're using the proper time frame when you're responding to requests that your company might receive. The two statutes also have different look-back periods. So Shine the Light covers information disclosed to third parties within the preceding calendar year, but CCPA has a look-back period of 12 months preceding the request. So depending on the time of year, those may not be the same thing. And then in terms of verification of identity, you may recall that CCPA has some very detailed procedures for that. However, Shine the Light does not include any steps on verification. It's often thought that, that this is the case because the information under Shine the Light that's provided in the accounting is not unique to an individual and therefore isn't as sensitive as what might be disclosed in response to a CCPA right to know request. At this point, you're probably thinking that situations where Shine the Light applies sound like sales under the CCPA. And you're right, there's a ton of overlap between these two statutes. Under the CCPA, sell, selling, sale, sold, etc. mean selling, renting, releasing, disclosing, making available, etc. a consumer's personal information to a third party for monetary or other valuable consideration. And as you can imagine, most scenarios in which personal information is being disclosed to a third party so that the third party can use the information to market its products tend to involve some kind of payment or other benefit flowing back to the business that provides the information. So there's extensive overlap between Shine the Light and CCPA's sale rules. Whenever you are analyzing the potential for a sale under CCPA, you'll also want to just make sure that you're thinking about Shine the Light and that you understand whether the law may apply to that transaction as well. What happens if a business violates Shine the Light? Well, as with CCPA, the business can face some steep costs. In 2018, we saw an uptick in lawsuits brought under this statute. These were primarily brought for non-compliance with the accounting requirement, But it does seem that perhaps there was renewed interest in this statute as a result of CCPA passing that year. Shine the Light includes a private right of action of its own, which provides for actual damages plus civil penalties of up to $3,000 for willful, intentional, or reckless violations, and up to $500 for any other type of violation. Last, it also includes a provision for costs and attorney's fees to be paid to prevailing plaintiffs. So far, claims under Shine the Light have not been brought in the same litigation as CCPA claims, perhaps due to the focus on data breaches in the CCPA litigation. You might recall from prior episodes that the private right of action under CCPA is only for data breaches. Nonetheless, the high penalties for violating Shine the Light, as well as the attorney's fees provision, make this an attractive claim for plaintiff's counsel, supposing they have the right set of facts. It may provide some comfort to businesses that there's also a 90-day safe harbor for non-willful late compliance. This allows a business upon notice to cure the issue with Shine the Light and avoid a lawsuit. So that's Shine the Light. Before we close, let me give you a few best practices for how to comply with this law. You'll want to review applicable contracts to determine if disclosures of personal information to third parties are for the third party's own direct marketing purposes. If Shine the Light applies, you need to include in your privacy policy either a mechanism for customers to opt in, for them to opt out, or information on how to request an accounting. You should consider whether to process requests for an accounting in the same manner as CCPA right-to-know requests. But remember, there are different response times and different requirements for what must be disclosed. Last, we recommend using reasonable means for verification, such as login information. Remember, these rights are only for existing customers. So now, you've had a little bit of background on Shine the Light. You can see I'm still here in the dark. Hopefully for you, the sun is up, all has been illuminated, and you know how Shine the Light fits together with the CCPA. This concludes Frenemies Season 3. I very much appreciate your time and hope this presentation was helpful to you. If you missed any episodes in this season, which is called Pivot, 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 What Marketers Need to Know About the California Consumer Privacy Act, all of the episodes, as well as those in Seasons 1 and 2, are currently available for on-demand viewing on McGuireWoods' website. And stay tuned for Season 4. Oh my acronym, that's with 8 M's. Privacy Regulations Beyond California, which will be available on demand soon. And of course, please do not hesitate to contact me or any of my colleagues here at McGuireWoods if you have any questions about the topics covered in this series. Thank you so much.